Hey, J-Bo Nation! Shaming of Jay! He's not a dopey dummy.
The cotton-headed ninny muggins.
He gets laid. The court jester.
My neighbor!
The court DJ. It's time to dive into the case. To the case. Good morning, everybody. Good morning, good morning. Thank you for being here. Got Christine on the kick machine, my mom on the kick machine. Happy birthday to my dad. I don't know if he's watching. Happy birthday, Dad. Paulie 3, Dizzy, Mike on the kick machine. Dawn, Donnie, Shannon L, Debbie, Joanne, Sarah, Carrie 28, Jonathan, Missy, Dizzy, Mooney, Sherry, Charlotte, Mia, Miko, Sweet Lou, Cindy Arnold, Shannon L, Debbie, JD, Jonathan, Mike, Janine. Good morning, everyone. Thanks for being here. Cindy. I hope I didn't. Janet, Missy. I hope I didn't. Thanks for being here. Catherine, Todd, Sky Troop, Deb, Arena. No more manly adventures this morning. However, yesterday I had to use a Sawzall. Very manly. Bonnie, good morning. Laura, good morning. Shout out my shorts more? Like my basketball shorts? Oh, my short video. Okay. Good idea, Laura. Janine. Thanks for being here, everyone. Mia, we got two Mias here. Good morning. Good morning. Thanks for being here. Sounds good. Sky Troop Afy, good morning. Hope I got everyone. Pepper, good morning from Missouri. P.I. Lisa, good morning. Donnie, good morning. Nora Vista Shuda. Donna White, good morning. Let me just make sure we don't miss anything here. Squadoosh. Uh-oh. What happened there? We gotta... Oh, that's why. All right. I don't know. I have no idea what happened yesterday in this case. Yesterday is a blur for me. Today, by the way, folks, good morning, Ashley. Miko says, have a grateful day, Jay's dad, because she knows my parents are deadheads. Today will be a half day, folks. Got to pick up Brian again. Half day. Half day.
Are there any matters we have to take up before the jury comes out?
Yes, Your Honor. I did some additional research last night. It's regarding some of the matters that were raised
Here we go.
yesterday, primarily on...
First of all, this guy looks like he got a haircut, but of course he's immediately starting out. Hey, Afy. Hey, Southern Charmed. Hey, Pamela. Hey, Angel Baby. Good morning, everyone. Good morning.
Direct. And in checking the case law before, and as I said, this came up late in the day yesterday, and I certainly didn't want to raise this in front of the jury. The state was permitted to ask Mr. or Officer Kimball questions about what he thought was odd or strange about the defendant's answers or things she wrote or didn't write. He was also allowed to opine about what he believes he saw in the truck and his opinion on what that meant when the truck turned down. Maybe it was Green, maybe it was Milford Street, I don't recall. I wanted to check on the law. Those are the kind of things that go directly to the province of the jury. It goes directly to allowing a witness to testify as to their opinion by a police officer, not an expert, but still as a trained investigator as to what he believes the evidence showed, and more concerning to me, what he believed about my client. So by saying things which he said were strange or odd, that is the same as opining about his opinion about her truthfulness and credibility. And I note, Your Honor, I looked up some cases. State versus Rivera at 169 Con App, 343. More importantly, LaPointe versus Commissioner, 316 Connecticut, 225, so specifically at note 83. That's a 2015 Connecticut Supreme Court case. State versus George A, the letter A, 308 Connecticut, 274. My concern, Your Honor, is at the beginning of this case, before evidence started, I filed 2 motions in limine. One specifically dealt with law enforcement opinion regarding the credibility or truthfulness of the defendant. The other one, filed the same day, was a motion in limine to preclude testimony.
Good morning,
that
everyone.
Contains or references
Thanks for being here.
Speculative statements, theories, or opinions of law enforcement. Based on Practice Book Section 42-15, I raised these issues because I was aware, because I've had this case for years, I've reviewed everything, there was a danger that this type of prejudicial evidence and interference with, because police have made these speculative statements in reports and in opinions. If Your Honor ever read the arrest warrant, half of it is their theory or opinion that is not based on fact. It's based on their own, I would submit, strained references and speculation. But what makes this particularly concerning to me, Your Honor, is that I had asked that these matters be at least addressed at the beginning. Your Honor, I think, used the metaphor about you were going to slow pitch this, if I remember, regarding some of these issues and wait till they came up during the trial. Well, at least these motions put the state on notice that these were issues I was concerned about, and I would have thought it would have behooved the state to then say there are a couple of matters at this point we are going to get into these issues and we need a ruling on whether they're coming in or not. The court has suggested somehow that cross-examination will take care of these issues. I submit that that's impossible once the bell is rung, and it's impossible to unring the bell on these matters that are prejudicial. And I suggest that because they go to issues that the jury must decide, they directly impact the defendant's constitutional right to fair trial, to a jury deciding the facts of the case rather than police officers, and more importantly, to due process and the right to prepare a defense. Since we anticipated these matters at the beginning and the court did not rule, and I will note that there's another matter that's going to come up today on the same issue that I'm assuming a number of police officers are going to give their opinion about a red truck that passes in 1 or 2 seconds on one or more highways, and they're going to say, yeah, that's the Tacoma, that's the same vehicle, whatever. I'm assuming that's what's happening today, and that's why it's important to raise this now. I understand that I also objected to these matters on the record, incited opinion, improper opinion. The jury can decide this, what they heard for themselves, etc. And I was overruled on those issues. And we did express concern, and it's impossible, I think, once the jury hears this, to be able to unring that bell. It was unduly prejudicial to allow this witness, and again, it was on redirect, and to be subject to leading questions for that whole, isn't it a fact that, isn't it a fact that, this was strange, did you find this odd, etc., etc. And then I was precluded from bringing up other things that Your Honor thought, that didn't open the door that wide, etc., etc. I'm just doing this for the record, obviously, because I didn't have a chance to do this while the jury was in the room. I would note, Your Honor, that although these cases, there are cases that say that when I talk about general behavior, how people generally react, when they're being questioned, that there's basically, which I will note, I at no point asked Mr. Kimball, Officer Kimball, whether he thought that Michelle Troconis' body language suggested anything. I talked in general. People are educated, uneducated, people have experience of how they react in general. And that was the reason that Mr. McGinnis used for being able to ask specific things about Ms. Troconis, not about what people do in general. And so I submit that it not only invaded the province of the jury, but went directly to an opinion about my client's truthfulness, her credibility, that what she said was strange to him. It went to her behavior, not in general to what people do in general. It violated the law. It also, I note, Your Honor, if I could just for a moment note, there's even a section in Judge Prescott's book, section 7.10.4, that talks about the impropriety of witnesses, talking about the credibility of other witnesses, other people, but I submit that it goes directly to the right to a fair trial when it's credibility questions and suggestions about the defendant herself. I also, at this point, Your Honor, wanted to address an issue and I'll just note there are two other cases that I wanted to bring to the court's attention. State versus Leniart, 198 Connecticut Appellate 591. It's a 2020 decision. It's well established that the federal Constitution requires that criminal defendants be afforded a meaningful opportunity to present a complete defense. And the right to offer the testimony of witnesses, to compel their attendance if necessary, and in plain terms, the right to present a defense and the defendant's version of the facts, as well as the prosecution's, to the jury, so that it may decide where the truth lies. So when yesterday the court said that the issue of Dr. Ehrman's report is collateral, I submit, and this is going to come up, much of our defense is about what